Member C. Lipsy presiding. Please be seated. Clerk calls the case of the people of the state of Michigan versus Jason Brian Dalton, case number 2016-0287-FC. Please state your appearances for the record.
Good morning, Your Honor. Jeff Getting, prosecuting attorney. I'm here on behalf of the people of the state of Michigan.
Your Honor, Jeff Williams, assistant prosecuting attorney on behalf of the people also.
Jason Dalton on behalf of Mr. Dalton, Your Honor.
Good morning, gentlemen. This is a time and place set for the trial of the people versus Jason Dalton. Court has been informed that there has been a resolution in this matter. Is that correct?
That's my understanding, Your Honor. We would ask the court to place it on the record here today.
Yes, Judge.
That case, Mr. Williams, if you could state what the agreement is at this time.
Your Honor, there is no sentencing agreement in that Mr. Dalton will be pleading to all counts against him. Those due, as the court knows, comes with a mandatory sentence. However, I believe there's some things Mr. Solis might want to say about the reasons.
Okay, Mr. Solis.
Judge, first of all, as a housekeeping matter, at this today I will be withdrawing, because I had not officially done so, withdrawing my motion for insanity. The reason for that is that the independent forensic examination that I had done does not meet the legal requirements of insanity, Judge. So I'd like to officially
Withdraw
that.
Mr. Williams, the prosecution have a position on that?
We have no objection, Your Honor.
Court will accept on the date of the trial a withdrawal of that defense position as originally noticed by the defendant. Mr. Solis.
So, Judge, today I want the record to reflect that discussions of plea offers have been going on between my client and I for months since this case has been pending, and I spent an hour and a half with my client, Mr. Dalton, this past weekend, and I've discussed the pros and cons of any potential plea, especially as charged. That's what's being done today. He understands those consequences. He is doing that against my advice. But in speaking to Mr. Dalton, there are reasons for that. There are personal reasons to him. He does not want to put his family through that, or the victims' families through the trial. So it's his decision against my advice, but I obviously will have to do that.
Thank you. Under those circumstances, Mr. Williams, what is the agreement?
Your Honor, Mr. Dalton will be pleading guilty to all counts. In counts 1, 3, 5, 7, 9, and 11, he will be entering a plea to first-degree premeditated murder. In counts 13 and 15, he will be entering a guilty plea to the count as charged, assault with intent to murder, and he will also be entering a guilty plea to the associated felony firearm charges, which make up the even number counts in the felony information.
Mr. Solis, is that your understanding of the plea agreement?
We call it a plea agreement, but that's my understanding, Judge, of what's been offered.
Okay. Prosecution has offered that, and it would appear that the defendant has agreed without any agreement as to sentencing, which is either subject to statute or to the court. Mr. Dalton, if you would stand. First of all, is that your understanding of the plea agreement?
Okay. Is that your understanding?
Yes, it is.
If you would come forward, hopefully there's a microphone here. I would ask that he be sworn.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. For the record, your full name is Jason Dalton.
Correct.
Mr. Dalton, court has been advised of your intent to enter guilty pleas as to the various counts of this information. You should be advised that if you do enter such a plea, you will be waiving or giving up certain legal rights. You understand that?
Yes.
I'm looking for the advice of rights. Okay. I'm going to show you a document entitled Advice of Rights. Have you seen this before?
Yeah, I've read it earlier today.
Is that your signature at the bottom of the page?
Yes, both of them are.
You understand that if you enter a guilty plea, you will be waiving or giving up many of these rights because we won't be going to trial.
Yes, that's what Mr. Sluice explained to me.
Okay. You also understand that you're going to modify certain rights that you would have to an appeal. If you had gone through the trial, were found guilty, sentenced, and you didn't like the sentence, you'd have the right to file an appeal with the Court of Appeals. The Court of Appeals in that situation is required to review the record. The preliminary matters, everything leading up to the trial itself, to see if there are any errors committed either by myself or by the attorneys that would justify setting aside that particular conviction. The Court of Appeals doesn't necessarily have to find anything. Most of the times they don't. But they do at least have to look if you file an appeal in that circumstance. That's called an appeal of right. On the other hand, if you enter a guilty plea and for some reason don't like the sentence, you still have the right to file an appeal. But in that situation, the Court of Appeals would have the option of looking into the matter or not. It would be their choice. That's called an appeal by leave. You understand the difference in the two situations?
Yes, I do.
Has anyone threatened you to get you to enter a plea today?
No.
Besides what's been put forth on the record, has anyone promised you anything to get you to enter a plea?
No.
Okay. You're doing this voluntarily of your own free will.
Yes, I've wanted this for quite a while.
You understand that if you change your mind or say that you didn't want to enter a plea, the testimony you're giving right now can be used to support the fact that the plea is voluntary at this time. You understand that?